And welcome, sir. And how's your health? Justice Ramkumar, it's always a pleasure catching up. And with Shyam Padman and SK Menon, I'm feeling that I'm right now in Kerala on the group of Shyam Padman on their webinar.
Yes.
And therefore, I was requesting Mr. Shyam, he will introduce the topic, just like on that format. We'll try to learn some nuances from that. And I'll just simplicity say that public interest litigation, as a lawyer, as a student of law and common man, we are all interested to know what is the legal journey of public interest litigation. Therefore, we thought that once we have an erudite speaker like SK PREMRAJ Menon, he would give us the journey as to how this law has evolved, as to how the telegram, letter, or any email can be converted, or even reading a newspaper can be converted into a public interest litigation. How the larger social causes have been taken over in the shape of public interest litigation, and what benefit at large it has happened, and where it is a private interest litigation, how that has been sieved out, and how the evolution of the rules within different courts have evolved. With this all in mind, I will request Mr. Shyam Padman to just give an introduction, and then we will ask Prem to take over.
Because thank you very much, Ramkumar sir, namaste. And nice to see very familiar faces of our platform here. Like Vikas said, I think it's, end of the day, whether it is from Kerala or from Delhi or any other place, as long as we as students assemble together in any platform, I'm sure that it's wonderful, because it's all legal empowerment through interaction. That's what's happening. Because
this is India. This is India.
This is India, absolutely. Because
rather, I would say nowadays it's pan world. As we thought, the local issue, think be local, be vocal, and think global.
Correct. Act locally, think globally.
Yeah.
Very good. Because congratulations on your good show, in the sense like it's a great service that you are all doing, in the sense like bringing good faculty and then dissemination of knowledge, interaction. It's empowering, really. It's really nice to. Congratulations to you first of all, and it was quite a surprise, because I just came to hear, like Ramkumar sir said, to hear what Prem has to say, and I was not at all prepared for anything. But now that you are requested, I cannot turn you down also, except for when you call me as a speaker, wherein I can politely, of course, decline when I said when.
So we will ask Justice Ramkumar to give a stay on that.
That of course.
I'll be a silent spectator.
That of course. Justice to doorsteps, or access to justice as a fundamental right, has always been recognized. When we may not find it spelled out in very many words in the Indian Constitution, Article 21, which says that nobody shall be deprived of his life or personal liberty except through procedure established by law. The personal liberty and the term life has been given an extended and a wide connotation and meaning by the different judgments of our apex court and other courts for that matter. And there are international instruments also which makes it mandatory that justice should not be at a premium in any civilized country. It should be freely accessible to everybody. Then only the right, you can say that I got a right to live in a society, because any relief without a remedy, what is the use in having a right? So access to have remedies. So that is why in India, we had a revolution that was brought about by which we nomenclature as Justice Bhagavati and Justice V.R. Krishna era, wherein we had something known as PIL and SAL. That is public interest litigation and social action litigation, wherein the intricacies, technicalities, etc., all those things were subservient to dispensation of justice. The concept of locus standi, cause of action, etc., paled to insignificance, and what mattered was only dispensation of justice or access to justice to all the Indian citizens. Today, we have a wonderful speaker to take us through the nuances, the history, the development, and now how, to a certain extent, Prem, you may correct me also, but public interest litigation is now frowned upon by courts in the sense like it is being misused. Anything that is misused, maybe there is a reason for having the restrictions. There are numerous guidelines now that has come up. Now, filing a public interest litigation is more onerous than having an ordinary writ petition is what I would have my take on that. So with these few words, again, thanking Vikas for the wonderful show and Justice Ramkumar sir for the presence in this platform today, which gives more grandeur to today's presentation. And Prem, who I need not say anything more about him. He's a mobile encyclopedia. He is well read. He is. I'm sure that whenever he says something, he does his homework properly. And every time when he addresses us, we have something to take home. With these few words, may I hand over the session to the speaker of the day, Sri S.K. PREMRAJ MENON, my younger brother.
I will just before he takes over the lead, as you said, the grandeur has become better, and I would say it's not my platform; it's a common platform, as you said rightly, that where you have to share the knowledge. That's the best way for caring. Amongst us, we have also Justice Kotandram, and we are too delighted to have him on the platform for a minute. We will unmute him also. And
Kotandram sir, namaste.
What a pleasant surprise.
Sir, thank you for joining us. We are actually delighted for having you on the platform. And I will ask Mr. Prem also to give introduction about Justice Kotandram. Over to you, Prem.
Well, good evening, everyone. And first of all, thank you so much, Vikas, to have afforded me with an opportunity of talking on this platform again. And I do acknowledge the presence of Justice B. Ramkumar and Justice Kodandraman. And it would be under their watchful eyes, I would be venturing to voice my views on this peculiar topic, which is just like a vast ocean. And as I say every time, I am just a toddler in this particular field, and I do not dare to enter the waters or the ocean. I would always prefer to stay on the banks. But with these legal luminaries around, let me just try to touch my feet upon the water, at least to this particular topic, so that I can do justice to the topic. The public interest litigation, which as we know as PIL, it is now the most effective weapon in the armory of law. Each and any one for attainment of social justice to the common man. It plays a very, very crucial role in the justice system, and it could achieve all those objects which could hardly be achieved or accomplished through what we call the conventional private lawsuits. The public interest litigation in India, that serves as a vehicle to create and enforce the basic human rights, which we have in Part 3 of our Constitution, better known as the fundamental rights. And it is critical to the very sustenance of a democracy like India. If properly used, the public interest litigation, it can address the needs of the citizens when the legislative lethargy is afflicting. In this talk, I would earnestly endeavor to voice a bird's eye view of the mechanics and dynamics of the public interest litigation before this August assembly. And as a forward, when Mr. Vikas and Shyamatan told me to bring out the various other nuances also, I shall try my level best with my limited knowledge. I do have only a minimum knowledge about all these things. Anyway, we all know that the public interest litigation, that obscures the traditional boundaries of power in a liberal democratic polity. Democracy is well reinforced by the expansion of standing to include any citizen who has suffered what you could call a rights abuse. Public interest litigation, it is designed to serve the very purpose of protecting rights of the public at large through vigilant action by public-spirited citizens and for attaining speedy justice. It could also contribute to the good governance by keeping the government also accountable. But with the profound need of this device, it has been plagued, as Shyamatan told you, by the misuse by such persons who have been filing these bills just for the sake of publicity, and those with vested political interests, as we see in the past few decades. That would be an undemocratic and perilous propensity which is to be impeded by judicial attitude. The iron hand of law that should heavily come down on such litigants. Steps and reasonable care should be taken to make sure that the public interest litigation essentially is one for public interest, and it should not get corrupted into becoming what you could say as a political interest litigation or a publicity interest litigation, both of which also you could get an abbreviated form as PIL. The misuse of public interest litigation, that will stop when the courts are vigilant, and the challenge is for the state to prolong a balance in allowing the legitimate public interest litigations and of course discouraging all mischievous ones. The concept of PIL that originates from the United States of America in the late 19th century in the case of Clarence Gideon versus Wayne Wright. That's a 1963 litigation wherein the US Supreme Court, by a thumping majority of all 9 judges, held that the states are required to provide legal aid or legal counsel to indigent defendants who are charged with felony. And it slowly grew from there. It was towards 1975, 1976. The great American professor by name Abram Shays, he popularized or coined this particular term, public interest litigation. And he describes that particular term as a practice of the lawyers or public-spirited individuals who seek to bring about a social change through the court-ordered decrees that reform the legal rules, enforce the existing laws, and articulate all public norms. Now, just before going to this public interest, we would see in a very early judgment of our Supreme Court, what is public purpose? This is in a constitutional bench of our Supreme Court. In State of Bihar versus Kameshwar Singh, AR 1952, Supreme Court 252, wherein public purpose is defined in a vague manner. The Supreme Court goes on to say, even though this particular term is not capable of a very precise definition, and it does not have a very rigid meaning, it is elastic and it takes colors and shades from the concerned statutes, and what is public interest or public purpose today may not be the same some decades later. Public interest is thus a dynamic concept. Its amplitude is so wide. Anything which would affect directly or indirectly, or is likely to affect the rights and interests of the general public or any section of the public, it would be public interest. In India, the first case where public interest litigation is seen defined is that in Democratic Rights versus Union of India, 1982, 3 SCC 235, in which Justice Bhagwati defines a public interest litigation and observed that the public interest litigation, it is a cooperative or rather a collaborative effort by such persons who would be the petitioners therein, the state of public authority and the judiciary to secure observance of constitutional or the basic human rights, benefits and privileges upon the poor, downtrodden and vulnerable sections of the society. Later, 10 years later, in Janata Dal versus H.S. Chowdhury, AER 1993 Supreme Court 892, one of the greatest judges India ever seen, Justice Ratnavel Pandian, speaking for the bench, in detail, he goes on to explain the public interest litigation, its origin and the meaning. In paras 48 to 51 of the said judgment, he answers the question, what a pill means and what a pill is. And he goes on to survey and explore a plethora of judicial pronouncements and refers to the Oxford English Dictionary, the Shroud's Judicial Dictionary, and the Black's Law Dictionary. Another great judgment is that of Justice Dalbir Bhandari in 2010. That is State of Uttaranchal versus Balwant Singh Chaufal, AER 2010 Supreme Court 2550, which extensively it would deal with every nuances of public interest litigation. He goes on to state that the origin and evolution of public interest litigation in India that emanates from realization of constitutional obligation by the judiciary towards the vast sections of the society, especially the poor and the marginalized sections, and that this particular jurisdiction, it has been created, or rather it has been carved out by judicial creativity and craftsmanship. The court also took note of the definitions of public interest litigation in the Black's Law Dictionary and the Advanced Law Lexicon. And of course, diverse judicial pronouncements also were referred to. The judgment of Justice Krishna Iyer in the constitution-based decision in Fertilizer Corporation Kangar Union versus Union of India, AIR 1981 Supreme Court 344, also is worth mentioning, as he goes on to speak a lot about this public interest litigation. I would just digress for a moment. After gaining independence from the British rule on 15th of August 1947, we the people of India, we adopted the Indian Constitution. Among others, the Constitution of India aims to secure to all its citizens justice. You have social, economic and political. Then you have liberty of thought, expression, belief, faith and worship. Then you have equality of status and of opportunity, which we see in the preamble. And mind you, these aims, they were not merely aspirational. The founding fathers, in fact, they envisioned, or rather they desired or intended to establish an India without any divisions of caste, creed, religion, race and sex, where everyone had equal rights and opportunities. They wanted to develop our country into a perfect egalitarian society where all the fundamental rights were secure, they were free from exploitation, as well as subjugation of the long suppressed populace of this poor country at that point of time. We know that the main tools employed to achieve such social change are the provisions on fundamental rights and the directive principles of state policy, which in the words of Granville Austin, who in his book titled The Indian Constitution, Cornerstone of a Nation, it's a book which is published during 1966. It describes part 3 of our constitution, that's the fundamental rights as well as the directive principles of state policy, as the conscience of the constitution. It was to ensure that the fundamental rights, they do not remain empty declarations. The founding fathers made various provisions in our constitution to establish an independent judiciary, because this is related, correlated. The provisions regarding fundamental rights, directive principles and independent judiciary, together they provide a very firm constitutional foundation for the evolution of public interest litigation in India. our founding fathers of the Constitution, they envisioned that the judiciary as a bastion of rights and justice. The power to enforce the fundamental rights, it was conferred on both the Supreme Court and the High Courts, which we see in Articles 32 and 226 of our Constitution. The public interest litigation, it can be defined as a litigation in the interest of that nebulous entity, the public in general. Earlier, the view was that only the aggrieved party, he could personally knock the doors of justice and seek remedy for his grievance, or any other person who was not directly affected could not knock the doors of justice as a proxy for the victim or the aggrieved party. In other words, only the affected party himself or herself had the locus standi to contemplate a litigation and continue the same, whereas a third party who is not affected, he was deprived of the term locus standi. As a result, there was hardly any link between the rights guaranteed by the Constitution of our nation and the laws made by the legislature on the one hand, and the vast majority of the illiterate citizens on the other. However, this scenario, it steadily gets transformed during the post-emergency period, when the Supreme Court started tackling the problems of this access to justice by the poor people through radical changes and alterations, which of course were made to suit the requirements of locus standi and of the person aggrieved. In fact, it was the splendid effort of Justice V.R. Krishna Iyer and Justice P.N. Bhagwati which were instrumental of this juristic revolution. It was in S.P. Anand versus H.D. Devagowda, AER 1977, Supreme Court 272. The Supreme Court was of the view that no one had the right to waiver of locus standi rules, and the court should permit it only when it is satisfied that the carriage of proceedings is in the competent hands of a person who is genuinely concerned with public interest and is not moved by other extraneous considerations. The Supreme Court observed about precaution which should be taken by the people who move the court for public interest, that those who invoke the court's jurisdiction seeking a waiver of locus standi, they must exercise restraint in moving the court by not plugging in areas wherein they are not well versed. And as a person seeking to espouse a public cause, such person definitely owes it to the public as well as to the court that he does not peevishly rush to the court without undertaking a research, even if he is qualified or competent to raise the issue. That means a good cause, we all know a good cause can be lost if a petition is filed on half-baked information without a proper research, or by a person who is not qualified and competent to raise such an issue. As the rejection of such a petition, that may affect third-party rights, because it's a public interest litigation, where you can even have the rules of res judicata also, which is upheld by the Supreme Court in ever so many decisions, unless you show that the other litigation, it was not really concerned with public interest. I should come to that a bit later. Now, the seeds of the idea of public interest litigation that were first sown in the judicial soil of India by none other than the great legendary Justice Krishna Iyer in 1976. That is the case in Mumbai Kamagar Sabha versus Abdul Bhai, AER 1976, Supreme Court 1455. The primary announced instance of public interest litigation, as we all know, is Husainara Khatun versus Home Secretary to the State of Bihar, which is AER 1979, Supreme Court 1369, which bases itself on the brutal states of jails That is a public interest litigation which comes up before Justice Bhagwati in the name of the suffering prisoner Husainara Khatun. And Justice Bhagwati broadened the rules of locus standi to community orientation from the traditional individualism through the public interest litigation. And of course, 3 years thereafter, he gives a very extensive exposition in S.P. Gupta versus Union of India. That's AR 1982 Supreme Court 149, which we popularly know as the judge's transfer case. Justice Bhagwati, he goes on to observe that when a legal injury is caused to a definite class because of the violation of their basic legal rights, and such person on account of his or her poverty or illiteracy, they are unable to reach out to the courts for relief, then any member from the public can apply either under Article 32 or under Article 226 of the Constitution, seeking for judicial relief for the legal wrong which is caused. Since then, public interest litigation has turned into an intense weapon for the requirement of open obligations where official activities or offences brought about open injury. Now, any citizen of India is able to move either the Supreme Court or the High Court for lawful cures or remedies in all situations, whether the interests of the overall population or if it is the interest only of an area of the general society are in question. Justice Bhagwati did a ton to guarantee that the idea of public interest litigations, it was plainly articulated. He did not demand the recognition of procedural details and even treated as, because rightly said, the common letters and telegrams which were addressed to the courts as repetitions. I should come to that a bit later. Now, Justice Krishna again, in Akhil Bharatiya Karamchari Sangh, that is one of the trade unions of the Indian Railway versus Union of India, which is reported in the year 1981, Supreme Court 298. He goes on to hold that our current processual jurisprudence, this is a terminology which he has coined in a lot of decisions, is not of individualistic Anglo-Indian mode. Now, this is a broad-based and people-oriented, and it envisions access to justice either through class actions, public interest litigation, representative proceedings. Now, indeed, we the little Indians in large numbers seeking remedies in court through this kind of collective proceedings, instead of being driven to an expensive plurality of litigations, it's an affirmation of the participative justice in our democracy. Just see how beautifully he has said what he has said about this public interest litigation. And he goes on to hold that the narrow concept of cause of action, person aggrieved, and individual litigation, they are all becoming obsolescent in some jurisdictions. Now you have another constitutional bench decision in MC Mehta versus Union of India. You have a series of MC Mehta. What I'm saying about is 1987 1 SEC page 395, which goes on to term the public interest litigation. So kindly see the jurisdiction of the Supreme Court, which has been beautifully, another term comes in, epistolary jurisdiction. How beautifully it has been termed. Now this concept of public interest litigation, where do we find? It is in consonance with the principles which we see enshrined in Article 39A of the Constitution, which aims to protect and deliver prompt social justice with the help of law. Now, filing a public interest litigation, it is not as cumbersome as a usual case. As I told you, that even letters and telegrams were treated as repetitions, because Vikas wanted me to tell about that. I'll give you some examples. The first example which I would give you is that of Justice Krishna himself. In Sunil Batra versus Delhi Administration, AER 1980 Supreme Court 1579, where Justice Krishna entertains a letter by a prisoner named Batra, who complains of brutal assault by the head warden on another prisoner by name PREMRAJ. Then comes Justice Bhagwati's rule. In Veena Sethi versus State of Bihar, 1982 2 SCC 583, he entertained a letter from two professors of the Delhi University where they sought for enforcement of constitutional right of the inmates as a protective home in Agra who were living in inhuman and degrading conditions. Treating this as a letter by the Free Legal Aid Committee in Bihar, he went on with the repetition. Now another one, which I would cite as the example, is Rural Litigation and Entitlement Kendra versus State of UP. AR 1988 Supreme Court 2187, which also was a letter which was directed to be registered as a repetition, which mainly concerned with the allegations of unauthorized and illegal mining in the Mussoorie-Dehradun belt, which adversely affected the ecological system of the area, which led to severe environmental degradation or disorder. Then, Justice Kuldeep Singh in Citizens for Democracy versus State of Assam, AR 1996 Supreme Court 2193. There also a letter from a journalist called Kuldeep Nair. I don't know how to pronounce. Actually, I think it is Nair or Nayar because it is N-A-Y-R. So excuse me. Because Nayar, okay. Then if it's the journalist, Sri Kuldeep Nayar, he in his capacity as the president of the Citizens for Democracy, he went on to allege human rights violation of the detainees under the Terrorist and Disruptive Activities Prevention Act of 1987, the TADA, which we don't have now. And this letter was treated as a petition under Article 32 of the Constitution. Then you have the famous case of D.K. Basu. D.K. Basu was the state of West Bengal. AR 1997 Supreme Court page 610. This was a letter which was addressed to the Chief Justice of India, drawing news items as we see in the papers. I think in that case it was the news items in 3 papers. I think it was a Telegraph, the Statesman and the Indian Express, regarding deaths in police lockups and custody. It was also treated as a repetition. And the Supreme Court, there you can see, went on to exhaustively lay down the guidelines regarding arrest. So, though the Supreme Court, through public interest litigations, has found a new historical basis for the legitimation of judicial power and has acquired new credibility with the people, the portals of the court, they have been rather thrown open to the poor, the ignorant and the illiterate, and their cases have started flowing into the courts through these public interest litigations. The Mumbai Kamagar Sabha versus Abdul Bhai, the 76 decision which I just mentioned, that explains that test litigations, representative actions, pro bono publico, and like broadened forms of legal proceedings, they are in keeping with the current accent of justice to the common man and a necessary disincentive to those who wish to bypass the real issues on the merits by suspect reliance on peripheral procedural shortcomings. The Supreme Court goes on to hold that the public interest is promoted by a spacious construction of locus standi in our socio-economic circumstance and the conceptual latitudinalism that permits taking of liberties with individualization of the rights to invoke the higher courts, where the remedy is shared by a considerable number, particularly when they are weaker. At the risk of oversimplification and overlap, The pill discourse in India, that could be divided into three broad phases, which we see in Justice Dalveer Bhandari's decision in State of Uttarakhand versus Balwant Singh Chaufal, the 2010 judgment, which I mentioned earlier. AR 2010 Supreme Court 2550. We would notice that these three phases differ from each other in terms of four different variables. One is who institutes the litigation. Number two, what was the subject matter or what was the focus of the litigation. Number three, against whom the relief was sought. And finally, how the judiciary responds to that litigation. As we see in the 2010 judgment, the first phase begins during late 1970s and continues through 80s, in which era the public interest litigations, they were generally filed by public spirited citizens like lawyers, journalists, you had academicians, social activists, and so on. And as we see, most of the cases relates to the rights of disadvantaged sections of the society, such as child laborers. You had the cases of bonded laborers, prisoners, mentally challenged, like Sheila Bar said, that pavement dwellers, orgatellis, and women. The relief was sought against the action or non-action on the part of executive agencies, which resulted in violations of fundamental rights under the Constitution. And during this particular phase, the judiciary warmly responds by recognizing the rights of the people and giving directions to the government to redress the alleged violations. In other words, the first phase, the public interest litigations truly were treated, or it rather becomes an instrument of the type of social transformation, or rather a revolution, that the founding fathers had expected to achieve through our Constitution. The second phase of the public interest litigation comes during the 1990s, during which era quite a few significant vicissitudes in the anatomy of pill that occurs. In comparison with the first phase, the filing of pills that gets more institutionalized, that several specialized NGOs and lawyers, they started bringing matters of public interest to the courts on a much regular basis. The span of issues that range enormously from the protection of environment to a corruption-free administration, the right to education. In Vishaka case, we had the sexual harassment in workplace, relocation of industries, the rule of law, the good governance, general accountability of government, and so on. In this particular phase, the petitioners sought reliefs not only against the action of inaction of the executive, as we see in the first phase, but also against private individuals in relation to policy matters and regarding something that would fall within the domain of the legislature. Now, this response of the judiciary during the second phase was by and large much bolder, or I would call it rather unconventional, than the first phase. Some of the cases includes the famous Sarla Mudgal case, 1995 3 SEC 635, which primarily questions whether a Hindu husband who marries under the Hindu law after embracing Islam can solemnize a second marriage, and whether such marriage without having the first marriage dissolved under law, that would be a valid marriage for the first wife who continues to be a Hindu, and whether that apostate husband would be guilty of the offense under section 494 IPC. Then you have the three-judge bench decision in Delhi Science Forum versus Union of India, AR 1995 Supreme Court 1531, where the petitioners impugned the power of the central government to grant licenses to different non-government companies to establish and maintain the telecommunication systems in the country, and the validity of the procedure which was adopted by the central government for the said grant. As I mentioned earlier, DK Basu was the state of West Bengal. A letter based on news items regarding deaths in police lockups and custody, eventually leading to the laying down of guidelines regarding arrest. Another three-judge bench decision is that in Vishaka was the state of Rajasthan, 1997 6 SCC 241, which seeks for enforcement of fundamental rights of working women, and the court laid down guidelines for due observance at all workplaces and other institutions until a legislation was enacted for the purpose. And we see finally, this was during 1997, after the elapse of say 16 years, the Sexual Harassment of Women at Workplaces Prevention, Prohibition and Redressal Act of 2013 was enacted. Now the courts enforced fundamental rights against private individuals and also granted relief to the petitioners without going into the question of whether the violator of the fundamental rights was the state or not. Now this phase was the period when the misuse of public interest litigations not only began but also reached to a very disturbing level, which occasionally compelled the courts to impose fine on the petitioners for misusing the pills for private purposes. Pills started slowly sailing into uncharted waters. Now coming to the third phase, which is the present era, which starts from the 21st century, a phase in which we see anyone can file a public interest litigation seeking for anything. It has become so wide. Now the time is all set for judicial introspection and to maintain the checks and balances. It's by this time, you can see I told you that the seats were sown by Justice Krishna. Now by this time, those seats of public interest litigation which were sown by the judge, it was sown in the very fertile judicial soil of India. By 1976, that becomes a huge tree. And several parasites started growing on it. It is high time to trim down the branches. Now in the decisions in Singh versus Union of India, year 2004 Supreme Court, 1923. And then you have the Holy Cow Pictures Private Limited case. I think it is versus, I'm sorry, I forgot who was the respondent. I think it was Premchandra, whatever. It is the Holy Cow Pictures Private Limited case, which is AR 2008 Supreme Court 913. It is Premchandra Mishra. AR 2008 Supreme Court 913. That goes on to hold that it was quite depressing to know, kindly see the word used by the court, that on account of such trumpery proceedings initiated before the courts, innumerable days are wasted. The precious judicial time which could have been otherwise spent for disposal of genuine cases of genuine litigants. And the court takes note of the fact that the busybodies, the meddlesome interlopers, the wayfarers, official interveners, they are having absolutely no sort of public interest except for their personal gain or private profit, either of themselves or maybe as a proxy of others, or maybe for any other extraneous motivations, or maybe for the glare of publicity. Under the garb of public interest litigations, they resort to filing vexatious and frivolous petitions and criminally waste the valuable time of the courts, and as a result of which the serpentine queue which stands outside the doors of the court never moves, which frequent situation creates frustration in the minds of genuine litigants, and resultantly they lose hope and faith in the very administration of our judicial system. In that case, it was observed that the public interest litigation, it is a weapon which has to be used with great care and circumspection, and the judiciary has to extremely be careful to see that behind the beautiful veil of public interest, an ugly private malice, vested interest, or publicity seeking is not lurking. It is to be used as an effective weapon in the armory of law to deliver social justice to the citizens. Now, using the attractive brand name of public interest litigation, it should not be used for a suspicious product of mischief, and it should be aimed at redressal of genuine public wrong or public injury, and not publicity oriented or founded on personal vendetta. And finally comes the decision in Balwant Singh Chaufal's case, the 2010 decision which I have already mentioned, by Justice Dalbir Bhandari. And he lays down 8 directions to preserve the purity and sanctity of public interest litigations. Now, the directions which were given by the court were: one, that the court should encourage genuine and bona fide public interest litigations and effectively discourage or curb the public interest litigations filed for extraneous considerations. Second was, instead of every individual judge devising his own procedure for dealing with these bills, he thought it would be appropriate for each high court to formulate its own rules. Third was that the courts, they should prima facie verify the credentials of the petitioners before entertaining the case. Fourth was that the court should be prima facie again satisfied regarding the correctness of the contents of the petition before entertaining the case. The fifth direction was that the court should be fully satisfied that substantial public interest is involved. Sixthly, the court should ensure that the petition which involves larger public interest, gravity and urgency must be given on priority over other petitions. Seventh, the courts before entertaining these litigations should ensure that they are aimed at redressal of genuine public harm or a genuine public injury, and it is never one for personal gain made with private motives or oblique motives which is behind filing this bill. And finally, the eighth one, which we see right from 93, the court should ensure that the petitions filed by the busybodies for extraneous and ulterior motives, it should be discouraged by imposing exemplary cost or by adopting similar novel methods to curb those vexatious petitions and all other petitions which are filed for extraneous considerations. Now, to my limited knowledge, almost all the high courts have by now framed rules as directed in this judgment. And at this juncture, you can see the Supreme Court first formulated its own rules or its own guidelines on December 1st of 1988 based on a full court, and the guidelines, they stand modified suiting the timely needs. I think that this was probably done in pursuance of the observations of Justice Khalid in Sachidananda Pandey versus State of West Bengal, 1987, 2 SEC 295, where he expressed concerns over public interest litigations losing credibility, and he highlighted the need for restraint on the part of public interest litigants, as many such litigations were needlessly filed. He felt that it was necessary to lay down clear guidelines and to outline the correct parameters to entertain the public interest litigations. And he went on to hold that it was necessary to have some self-imposed restraint on this public interest litigants. Now, we have the state of Himachal Pradesh versus parent of a student of medical college. Also a lecturer, 1985, 3 SEC 169, which concerns with ragging. The Supreme Court goes on to say that the public interest litigations, that it was an innovative strategy which was evolved by the Supreme Court for the purpose of providing easy access to justice to the weaker sections of Indian humanity, and it is the most powerful tool in the hands of any public-spirited individual and social action groups to combat exploitation and secure for the underprivileged segments of the society their social and economic entitlements. Now, as pointed out, this is a highly effective weapon in the armory of law to attain social justice to the common man. And in the very same judgment, the Supreme Court goes on to state that it is difficult to see how many proceedings can be entertained by a court, keeping the petitioner before it anonymous or his identity as a secret. If the identity of the petitioner is not disclosed, how would the respondent against whom the relief is sought would ever be able to verify the authority of the petitioner or the credibility of the case which is brought by him? Now, it would be contrary to all canons of fair play and violative of all the principles of judicial ethics, propriety, and administration to entertain a repetition without disclosing the identity of the petitioner. Though the court knows who the petitioner is, you cannot mask the identity. This was again said in the Divine Retreat Center case, AER 2008 Supreme Court 1614, that public interest litigant, he must specifically disclose his identity so as to enable the court to decide that the informant is not a wayfarer or an officious intervener without any interest or concern, and that an anonymous repetition would not lie. Some of the landmark judgments regarding this public interest litigations, which each one of us need to read, one is Husainara Khatun versus Home Secretary to the state of Bihar. I already cited that judgment. 17 AR 1979 Supreme Court 1369. Then you have Sunil Batra versus Delhi Administration, AR 1980 Supreme Court 1579. You have the Fertilizer Corporation Kamgar Union's case, which I again said is a AR 1981 Supreme Court 344. It's a constitutional bench decision. You have the 7-judge bench decision in SP Gupta, which I have already mentioned. SP Gupta's case, which is AR 1982 Supreme Court 149. You have the People's Union for Democratic Rights versus Union of India, AR 1982 Supreme Court 1473. Then you have the Bandhu Mukti Morcha's case, AR 1984 Supreme Court 802. The Forward Construction Company's case, AR 1986 Supreme Court 391. And the off-court Olga Tillis versus Bombay Municipal Corporation, AR 1986 Supreme Court 180. That also is a constitutional bench decision. Then you have Umed Ram Sharma's case, 1986 2 SCC 68. You have another constitutional bench coming in the form of MC Mehta versus Union of India, AR 1987 Supreme Court 1086. You have the Rural Litigation and Enlightenment Kendra's case, which I have mentioned, AR 1988 Supreme Court 2187. You have Sheila Barsa, AR 1988 Supreme Court 2211. Paramanand Kartara's case, AR 1989 Supreme Court 2039. Then again I cited that Janardhan versus HS Chaudhary, 1992 4 SCC 305. You have Samata versus State of Andhra Pradesh, AR 1997 Supreme Court 3297. Then again you have Justice Dalveer Bhandari's case, Balwant Singh Chaufal, AR 2010 Supreme Court 2550. Then you have National Legal Service Authority versus Union of India, 2014 5 SCC 438, which we know, which declared the rights of transgenders. And you have Navtej Singh Johar versus Union of India, 2018 10 SCC page 1, which did away with section 377 of the IPC. All these cases, that gives a good reading. It was in Manohar Lal versus Sanjay Leela Bhansali, AR 2018 Supreme Court 86. A petition under Article 32 of the Constitution comes up before the Supreme Court as a public interest litigation, seeking the prayers that the film which was titled Padmavati, that should not be exhibited in other countries without obtaining the requisite certificate from the Central Board of Film Certification under the provisions of the Cinematograph Act of 1952 and the rules thereunder. And the petition also seeks for an issuance of a writ of mandamus to the CBI to register an FIR for the offence punishable under Section 7 of the Cinematograph Act of 52, Sections 153A, 295, 295A, and 500 of the IPC, and Section 4 of the Indecent Representation of Women Prohibition Act of 1986, and to investigate and prosecute the offenders in accordance with law. The then Chief Justice of India, Justice Deepak Mishra, the most grandiloquent judge after Justice V.R. Krishna Iyer, he goes on to hold that it was a most unfortunate situation showing how this public interest litigation was being severely abused, and that hunger for publicity or some hidden motive should not propel any litigant to come before the court filing such vexatious petitions, as they would sully the temples of justice and intend to create dents in the judicial dispensation system. And of late we see In Suras India Trust versus Union of India, 2017-14 SCC 416, a public interest litigation for the judicial time which was wasted by the petitioner, which was a trust, the Supreme Court imposed exemplary cost on the petitioner, quantifying the cost at rupees 25 lakhs, which was to be deposited with the Supreme Court Advocates on Record Welfare Trust. Ordinarily, the court would allow litigation in public interest if it is found that the impugned action is violative of any of the rights which is enshrined in Part 3 of the Constitution, and the relief is sought for its enforcement. If the action complained of it is palpably illegal or mala fide and affects a group of persons who are not in a position to protect their own rights on account of poverty, incapacity, illiteracy, or ignorance, or if the person or a group of persons who are approaching the court in public interest for redressal of a public injury which arises from breach of a public duty or from violation of some provision of constitutional law, or maybe again that such petitioner or the association is not a busybody of meddlesome interlopers and they have not approached with mala fide intention of vindicating their personal vengeance or grievances, or if the process of public interest litigation, it is not being abused by the politicians or other busybodies for political or unrelated objectives. Now, one needs to be aware of the fact that every default on the part of the state or public authority being not justiciable in such litigation. Then, if the litigation is initiated in public interest for such that if it is not remedied or it is not prevented, it would weaken the very faith of common man in the institution of judiciary, and it definitely would tumble down the very democratic setup of our country. Then if the state action is being tried to be covered under the carpet and intended to be thrown out on technicalities, a public interest litigation, it can be initiated either upon a petition which is filed or on the basis of a letter or a telegram or other information which is received, but only upon satisfaction that such information laid down before the court is of such a nature which requires examination, that one, the person approaching the court comes with clean hands, not merely clean hands. It should be clean hands, clean heart, and clean objectives. Then, that before taking any such action in public interest, the court has to be necessarily satisfied that the forum is not being misused by any unscrupulous litigant or politician or busybody or persons or groups with mala fide objective to vindicate their personal grievance or by resorting to some blackmailing or considerations which are extraneous to public interest. It is also the duty of the court to ensure that the petitioner has not been set up by some others and is not a mere nameless. The pill activism, it is fast moving into new arenas, arousing heightened expectations not only for vindicating the governmental commitment to the welfare of the oppressed and the victimized, but also for effectuating the social control, maintaining communal harmony, preserving rule of law, preventing the decline in public morality. And it is propounding the notion that the Constitution of India, it can be used both symbolically and substantively as a medium of non-revolutionary struggle against the domination and abuses of power. Now, it could be thus seen as empowering the victims to use the courts to force the government to fulfill its commitments. And the spectacular surge of these public interest litigations in India during the last decades, that is suggestive of the fact that the legitimacy of public interest action, it is beyond the pale of doubt. The aim of the legal system and law is to provide justice to the society. And the public interest litigation why now it has proved to be the medium in achieving this goal. Now, this is a sort of litigation which is filed in a court to protect public interest. And as I told you in the beginning of my talk, it has not been defined under any statute in the country, but it is based upon judicial interpretation by wise judges using their judicial craftsmanship. And the main aim of this kind of litigation, that is to safeguard the interest of the society and to see if justice is served to all, irrespective of poverty, helplessness, disability, inability, illiteracy, or whatever that. And by taking up the issues affecting the disadvantaged section, the bill aims to become a tool to bring social revolution through constitutional means, something that the founding fathers had envisioned at that point of time. And it made sure that the court take cognizance of matters relating to the environment, the welfare of children. You have economic exploitation, preservation of culture, ecological imbalance, delivery of justice for the same. Public interest litigation, as we see, it is an outcome of judicial activism also. The lone purpose behind this move is to make the judicial system more responsive towards the needs of that section of the society which, because of various reasons, cannot bring their grievances to the court to get it ventilated. And the aim is to make the judiciary more reformative. Now we see, even if a public interest litigation is there, it is the judiciary which serves as a sentinel for the society, and through this movement, the courts could order far-reaching remedial measures. Now, this particular tool, it is to uphold the fundamental rights, and the factor that leads to its growth, it is benign approach towards the downtrodden class. And the matters which are taken up by the legislature are particularly private and unrelated to the welfare of the populace. The growth of public interest litigation, it is because it is filed with the interest to protect the mass or the underprivileged. And we see that the bills have contributed to the protection of not only protection and enforcement of rights which were unnoticed and prevent the abuse of justice. It was an, as we know, it is rather an admitted fact that discrimination against underprivileged and the distressed, it is prevalent in the Indian society even now. Even when we are at a very advanced, we say we are a very advanced society still now. And to put off such injustice, the concept of pill stepped in. And of course, many people, as I said, are seen using this kind of pill as a harassment tool. And there was an influx of frivolous cases. Yet these litigations also were considered as progress in the Indian judiciary because they also focuses attention on achieving results about issues of larger public at an inexpensive rate. But the Indian public interest litigation, that experience, it shows to us that it is critical to ensure that the pill does not become a facade to fulfill private interests or to settle political scores or gain publicity. The judiciary in a democracy should not use the public interest litigation as a device to run the country on a day-to-day basis or to enter the legitimate domain of the executive and the legislature. The bill has expanded its jurisprudential horizons of human rights in India. And after the introduction of this form of litigation, the recognition of human rights as important as education, health, livelihood, everything becomes relevant. And this is a device which has rather broadened judicial remedies. On a theoretical level, if you see, the bill, it has helped the Indian judiciary in gaining public support and established legitimacy in the society. It has rather acted as an avenue to enforce diffuse rights for which either it is hard to recognize an aggrieved person or where the distressed persons, they have no incentives to knock at the doors of any courts. And some of the matters which are entertained under the public interest litigation are bonded labor matters, neglected children, non-payment of minimum wages to workers, exploitation of casual workers, atrocities on women of various kinds. You have environmental protection, environmental pollution, the disturbance of ecological balance, food adulteration cases. You have a maintenance of heritage and culture. Those from prisoners regarding their harassment, then regarding premature release from the jails, death in the jails, or transfer or release on personal bonds, speedy trial as a fundamental right. We see police against the police to refuse to register a case.
Custodial torture.
Exactly. Harassment by police, death in police custody, those complaining of harassment or torture from persons, especially belonging to scheduled caste and scheduled tribe or the economically backward classes, and so on. And the cases which cannot be entertained as spills would be the landlord-tenant matters, service matters, which we see in Duryodhan Sahu, then those pertaining to pension and gratuity, admission to medical and other educational institutions, petitions for early hearing of cases which are pending in the high courts and subordinate courts, etc. So as a whole, we see that the aim of the public interest litigation is to give to the common people access to the courts to obtain legal redress. Now, bill is an important instrument of social change and for maintaining the rule of law, accelerating the balance between law and justice. The original purpose for which a bill is meant is to make justice accessible to the poor and the marginalized. It's an important and very powerful tool to make the human rights reach those who have been denied all those rights. It democratizes the access of justice to each and everyone. Any citizen, be it any organization, whoever is capable can file the petitions on behalf of those who cannot or do not have the means to do so. It helps in judicial monitoring of state institutions like the prisons, the asylums, protective homes, etc. Now, this is a very important tool to implement the concept of judicial review. Enhanced public participation in judicial review of administrative action that is assured by the inception of bills. And of course, there are disadvantages as well. Now, these actions may sometimes give rise to the problem of competing rights. For instance, I will tell you, where a court orders the closure of a particular industry, which somebody complains as a polluting industry, the interests of the workmen and their family who are deprived of their livelihood may not be taken into account by the court. It could lead to overburdening the courts with frivolous bills by the parties with vested interests. Now today, it is no more limited to problems of the poor and the oppressed. Cases of judicial overreach by the judiciary in the process of solving socio-economic or environmental problems that can take place through the public interest litigations. And we can have the inordinate delays in disposal of the bill cases that may render many leading judgments merely of academic value, may not serve any purpose. So, to sum up, public interest litigation, it is a revolutionary stream which helps the common man to reach out his remedy, which is beneficial for the public at large, which was not earlier available to them, even before the actual damage is done. You need not wait till the actual damage takes place. Public interest litigation that has opened the new window of thoughts. And we should really profusely thank our judiciary who have coined this new concept, which is extremely useful for the public at large, because there are many examples present with us which would show that it really has helped the common person in diverse fields. And that brings me to the end of my talk. Thank you all for a very patient listening. Thank you so much.
Thank you, Mr. Prem. The entire journey you have covered so well. We do not know when the bullet train comes, but actually we got all the bullet points right now. And before we proceed further, we have amongst us Justice Rajiv Bhalla, former judge of Punjab Haryana High Court. who has also been on the platform, I will ask Sir to give the insights. We are unmuting him and we will ask him to come on the video. Yes, sir.
Can you hear me?
Oh yes.
Yes, sir. Your video is not there. Video.
You'll have a problem hearing me.
You have
No,
no
it's
problem.
audible,
You're perfectly audible, but not visible.
So your video. Yes, sir. Bala, sir. I will just connect with him. Meanwhile, we will have the insights from Justice Ramkumar.
Me,
Yeah.
I came here as a silent spectator.
So sometimes once you are
excellent.
watching a match, even the sex touches you.
Yes, thank you. Excellent articulation by PREMRAJ MENON. In fact, nothing strange in the presentation. He has not left any stone unturned. He is, in fact, he is our ready reckoner and our walking encyclopedia. See, all these citations he was giving extempore without any reference to any book or citation. This is an extraordinary dimension in which access to justice is provided to underprivileged and disadvantaged class of persons by relaxing the locus standi. The main reason is executive or legislative lethargy, as rightly said by Mr. PREMRAJ. In fact, it's a new vistas of access jurisdiction opened up by the Supreme Court. The only thing is, for the courts also, from the stage of creativity, adventurism, and activism, the court should not disintegrate to the level of abatement of blackmail, because of late this jurisdiction was being misused, abused by certain persons due to publicity or some other extraneous consideration. Court should not be a party to that. And I have one small question. What is your take on the Divine Retreat Center's case, where the Supreme Court said Chief Justice in the High Courts, Chief Justices alone should take suo motu action. Uni judges are debarred from taking suo motu action. According to me, it is a wrong attitude, wrong vision, because especially after the decision that all Chief Justices should be from outside. Supposing a Chief Justice in Kerala, he is from outside. He may not have any local interest, or he may not know the pulse of the state, pulse of the people of that state. As our experience shows that most of the Chief Justices were northward oriented, looking for their elevation to the Supreme Court. Therefore, they are not interested in the local situations, local tragedies, local problems. Therefore, according to me, the puny judges alone should be given that power to take suo motu action. In one case, a puny judge of the Kerala High Court took suo motu action, and for a very, very noble cause. It was curtailed by the Supreme Court in that decision. And not only that, Supreme Court went further to say that Chief Justices alone can take suo motu action. Do you agree with that?
I don't agree, because Supreme Court themselves, they have taken by way of writ petitions, which were addressed to personally to judges, not only the Chief Justice of India.
Yes.
So that also sets as a precedent, because any judge of the High Court is having the power under Article 226.
Even a magistrate is entitled to take suo motu action. Even a magistrate,
which we see in 133 CRPC. Yeah, absolutely true.
Excellent articulation. Well done.
Thank you so much, sir.
So in fact, in our High Court, what they do is, let's assume a judge can take a suo motu cognizance, but then he will say it will be placed before the whatever is the green bench. And sometimes we have judges who are the first puisne, as you rightly said, the first puisne judge takes the cognizance. But anybody who can take the cognizance, but he will direct that I read the newspaper, etc. Yeah. We have unmuted Justice Kothandaram, and we will ask his insights also.
Justice Kothandaram, your views.
I think his speaker is not on.
You better unmute.
No, he's been unmuted otherwise.
I see.
I think you will have to improve the volume of the speaker.
Speaker volume.
So that issue came with Justice Bhalla also. He said that I'm hearing it, but I am not able to put it across. Meanwhile, we will take one question. He says, how can you detect that a bill is there of the same nature of which another one is wanting to file in some other court? Is there any way out?
Beg your pardon, how? Just come again.
Let's assume he says that a bill is filed in one particular high court. Is there any via media to know that some other high court is also seized of that same matter?
No, absolutely. As of now, there is no such way to find out whether a bill is pending before some other high court. But if it is in the same high court, it will be treated as a batch of writ petitions, which we see even in the Supreme Court. In many cases, batch of writ petitions are being considered similar kind.
But when the respondent gets notice, he can say that there are other writ petitions.
But that would be only when there is a Union of India, let's assume. But if it is a state case, then he cannot say State of Punjab will not be able to tell that State of Kerala is also there, number one. The only remedy, I think, would be Google Baba.
So, but at the same time, I would tell you like this. Suppose a bill in one state that challenges a central statute, and the state says that a particular provision of that statute is violative of Part 3 of that central statute, then the decision of that particular high court that runs throughout the length and breadth of the country, because this is a central statute, which you see in Kusum Ingott's case of 2006, constitutional bench decision, which we see CBI was struck down as unconstitutional body by a division bench of one of the high courts in India. And of course, that is having the effect all throughout the length and breadth of the country, all throughout India. Kusum Ingott's that clearly manifests that particular position. If it's a central statute, and of course, if it's a state statute, that applies only to that state alone.
There was a judgment on that sonologist also. This Delhi High Court had struck down the action of the in a case of sonologist, wherein they said that you have to pass the test. Then the Punjab Haryana High Court, coupled with Himachal High Court, said that the judgment of the other state may not be binding, but it has a pervasive value, and they followed that. And more so when they said it is a central act, and once it has been held to be vitiated, then they said that it's allowed to be followed by others. Though it's a different matter than on the Supreme Court, it was slightly reversed.
If it is different, of course, it's having only persuasive effect. If it is
high time we had a law incorporating all the decisions of the Supreme Court, do's and don'ts.
I think there's only one more question. The only issue, if it can be addressed, is because a lot of judgments are to the effect, since I couldn't find the question. It said that in a lot of judgments, they say that in service matters, the bill will not lie. And in some judgments, you will find that they say it is an interesting question. There's a subtle difference between that. It's not actually within the contours of the service matters. And there are judgments to the effect wherein service matters have also been entertained. Let's assume that in some places it has been said that the DGP is not competent to hold the court. He is not competent to adorn that post. In some cases, they say that public interest litigation would not lie in a service matters jurisprudence. But in some, there are interferences by the court also.
No, service matters, generally it is prohibited. You have a plethora of precedents which flow right from 1997. Duryodhan Singh Sahu's case. Right from 97 you have. Service matters, it cannot lie. Because you can also see the Supreme Court guidelines of the Supreme Court also. Supreme Court made the guidelines as long as during 1988, December 1st of 1988. Service
Even
matters, it won't lie.
Specifically, fact, contractor person service.
Exactly.
But one of the reasons is that they say that it is because of the fact that it is a personal interest.
Exactly. It is a personal thing. But a day may come in the near future because expanding the horizons, maybe because you can ask for anything now.
Supposing a particular DGP, supposing a particular DGP.
The only enlarging scope is to the effect that wherein they say that similarly situated person should be granted a relief, and that is while exercising the power, and then they say that extended to all.
Yes, supposing a particular DGP is playing havoc, probably a bill may lie.
True.
So thank you to all the participants, and we just wish that we could have the insights from Justice Kodanand Raman.
Kodanand Raman is speaking. He is speaking. Only thing is we can't hear him.
We can only say that if
we are seeing his lip movement.
He is saying that he endorses what you have said, and as they say that when your lips are silent, then your heart can actually understand. That's and what you were made to understand. Thank you to all the participants, those who have been connected with us for the engaging webinars. And as Mr. Prem had said, that the seeds of knowledge can only be sown, but the fruits can only be cherished once. All the participants actually encourage us, because then you feel that what you're trying to disseminate the knowledge amongst the people is being well reached within the people. And tomorrow's session would be a glance over the appreciation of a solitary evidence by G. Karupaswamy Pandyan. He's a lawyer from Madurai High Court. Thank you, everyone. Stay safe, stay blessed. Tomorrow we will connect at 4 p.m. And thank you to Justice Ramkumar, who has been one of the backbones to encourage us, and people actually keep on sending us messages that you should call upon sir. After this platform, we will again request. Thank you to everyone, and thank you to Justice Kotraman, and thank you to Justice Allah, just Mr. Shyam Padman and SK Premraj, as you rightly said, that I might not say because today he was a sitting one. Today he was a sitting dictionary, not a walking dictionary. Thank you to everyone. Thank you.
Thank you so much. Thank you so much.